Now to our legal report. The trial of the white man who hunted down and killed an unarmed black jogger, Ahmaud Arbery, formally began today with the opening statements. Prosecutors saying in court these men murdered Arbery in cold blood based on false assumptions about him. The defense previewing a case that concedes the killing was, quote, tragic, while claiming the men who brought the lethal weapon to the scene were then the ones that had to resort to, quote, self-defense.
We are here because of assumptions and driveway decisions. And they made decisions in their driveways based on those assumptions that took a young man's life. And that is why we are here.
And it's tragic. It's tragic that Ahmaud Arbery lost his life. But at that point, Travis McMichael is acting in self-defense.
Even just that brief excerpt of the opening arguments can tell you something really big about this case. It's not a mystery. This isn't a murder trial about alibis, I was somewhere else, or alternative killers, you got the wrong guy. These men killed an unarmed jogger who was minding his own business, and both sides agree on that in court today. The defense is trying to find jurors who will view this as some kind of vigilante effort to track down Arbery as a valid activity, and then view the ensuing struggle as Arbery becoming the threat. The murder defendants are claiming they wanted to make a citizen's arrest, and this court will be evaluating that. This also involves human beings, and it was very emotional in court today. Arbery's mom upset, understandably, as the video of her son's killing was played by the prosecution. Sad and gruesome, but necessary, they say, for the jurors to see the facts of what happened. Indeed, many question whether this would ever be an indicted case had there not been the video. Prosecutors emphasizing what is on tape. They say Arbery was the one under attack first, and that any person might take measures to try to survive when attacked by strangers that chase you down with a gun. Now, this case is racially charged in several ways, and now the makeup of the jury itself is charged too, because defense attorneys use legal loopholes to cut out potential black jurors. It's now a nearly all-white jury that will assess the actions of these white killers, 11 white people and 1 black man. Now, that is so extreme, don't take my word for it. Listen to the trial judge who felt the need to openly condemn the discrimination found by the court, noting how many of the black candidates for the jury who seemed completely qualified were just repeatedly struck by defense lawyers, not allowed to be on the jury. The judge saying this, and you might go, okay, Ari, well, isn't the judge in charge? And if it's intentional discrimination, couldn't the judge stop it? But actually, as the judge basically makes reference to here, under Supreme Court precedent, an individual trial judge cannot actually prevent this outcome.
This court has found that there appears to be intentional discrimination in the panel. Quite a few African-American jurors were excused through preemptory strikes exercised by the defense. But that doesn't mean that the court has the authority to reseat.
The judge is doing what he does. That's his job. I'm going to do what I do. Translation. This is racist. The defense lawyers are striking people because of the color of their skin, because they're black, and they're using tricks that the judge is not allowed to prevent. And English translation, that's why he references so-called preemptory challenges. That's legal jargon. The jargon doesn't matter. The point is, even the judge in this case is calling it out and making sure people understand that under the rules, he doesn't have the authority to stop it. That's messed up. Critics say the result is that now a case involving allegations of racist violence includes a jury selected in a manner so racist it doesn't even reflect the local population. More black people live in that local area than are on the jury, about 27%. It's a legal issue that we actually noted in some of our reporting earlier this week. It stems from a controversial 1986 Supreme Court case that effectively allows this, because that precedent, it only bars outright racial discrimination, but not the other methods to get the same result, which means lawyers can get around the rule against outright racism. Some legal critics have called this a toothless and inadequate approach, and it drives outcomes like what we're seeing in this trial now, where Arbery's killers face a lopsided jury. As the New York Times reports, it is 91% white in an area that's about 64% white. And all of that may impact how receptive the remaining jurors are to the argument that these white killers were actually somehow on the side of the law as they tried to do citizen vigilantism that hunted down and killed an unarmed black man. So, we will keep monitoring that important case. There's another murder trial that actually gets into similar claims. Teenager Kyle Rittenhouse on trial for murdering 2 BLM protesters in Wisconsin. There was damning testimony today from a witness who initially saw this killer as really more of, according to the witness, an idiot than a lethal threat.
What did you think of him?
A babbling idiot.
Did you consider him a threat?
No.
There's nothing new about this kind of political violence across America. Indeed, what you need to understand is that every time there has been steps for racial and legal equality, advancing civil rights in America, there has been a rise in violence against black people and those who support civil rights, violence by the state, anti-black terrorism, and violence against people who may not be black but actually stand with black people for their equality, for their human rights. That happened to the Freedom Riders in the 60s. There was terrorism against those riders that involved murdering white and black people who were supporting civil rights, just as Rittenhouse is on trial for murdering 2 white people that supported the idea that Black Lives Matter, which is why he illegally obtained a gun. That's not in doubt, and showed up at a BLM protest and gunned down 2 people. That is the context for the consequences and the climate where people openly sympathize with vigilantism or even these killers.
So are you really surprised that looting and arson accelerated to murder?
He was in very big trouble. He probably would have been killed.
He's a good kid. He's a lifeguard. Kenosha was burning down.
How shocked are we that 17-year-olds with rifles decided they had to maintain order when no one else would?
That's the story. But if you reverse the race of the individuals, sadly, some of those people would say the opposite thing, which is a reminder of how racism hangs over all of this in a heavily armed society. And we're showing you the limits of a justice system that says racism is illegal. It does say that. You'll get a 9-0 ruling from the Supreme Court on that. Racism, for example, in a courtroom. But then allows things that lead a judge in America to stand up and say, everyone hear this, they are being racist in how they remove jurors. And who's going to decide whether you can openly hunt down and kill these people? Well, in our justice system, it will be the jurors. Remember all this talk about structural and systemic racism? It doesn't mean every single person is racist. Doesn't mean everyone's even aware of all this stuff. It means that in the structures of our system, most of which was built a long time ago when things were very different, there are all these ways that even when someone is put on trial, there's a lot of support for what on tape looked a lot legally like murder.